Marshall Chriswell is indeed on the line with us this morning for this installment of Marshall Law. Good morning to you.
Good morning. How are you?
Wonderful. Good to have you with us here today. Hey, there's a term out there that we hear of all the time. It's arbitration, and frequently we hear it in terms of a labor setting, but arbitration is not just for labor, is it?
No, it's not. Arbitration, it can be used in all sorts of civil cases, and there are arbitration cases where the parties voluntarily agree, okay, we're not going to go to a judge or a jury for a trial. We're going to go to an arbitrator or an arbitration panel to get this resolved because it may cost us a little less. We think that maybe the arbitrator has subject matter experience. In labor disputes, sometimes that's the case, right? You're going to an arbitrator that arbitrates labor disputes all the time, so they know the nitty-gritty specialized issues that are involved in that. So that's one reason that there are arbitrations that are done because it's required in a contract. You sign a construction contract with a builder to build a house, and they include a provision in there that says, hey, if we have a dispute, we have to go to an arbitrator. We can't go to a trial court. So there are all sorts of reasons that people end up in arbitration.
Does family law enter into that at all?
Family law doesn't generally proceed to an arbitration. Family law, more often, you go to a mediator, to a mediation in an attempt to reach an agreement. I guess there's nothing to prevent particularly a divorce case where you've got complex financial issues from going before an arbitrator, but it's certainly less common.
Okay. Well, let's talk about an aspect of arbitration, and that is compulsory arbitration. What is that, and what is the advantage or disadvantage?
Well, compulsory arbitration it's a requirement, it's a statutory requirement that many states, including Pennsylvania, have on the books, and it varies a little bit from county to county. Counties have some discretion in how they set this up. But for instance, here in Indiana County, any civil dispute where the damages are less than $50,000 has to go through a compulsory arbitration process. So you file a complaint, just regular civil complaint that you would file at the county courthouse, seeking damages for any manner of a car accident case, a contractor case, property damage, whatever it is, and you have to certify whenever you file, whether this is going to be a case that exceeds the jurisdictional limits, that $50,000, the jurisdictional limits for arbitration, or is it less than that? And if it's less than that, the court immediately compels you, compulsory arbitration, to attend an arbitration. So, and the arbitration is held before a panel of three local attorneys, so attorneys that are members of the county bar. Three attorneys are appointed to hear that case.
Oh, that's interesting. And I would assume then, therefore, that there's a pool of people who are appointed ahead of time that you're going to be one of our arbitrators, and we'll just pull three people out of that pool. Is that how that works?
Yeah, right. So basically, all of the practicing attorneys in the county bar are in the pool, and whenever a case comes up for arbitration, the prothonotary office, the courthouse, will pull. They'll take five names, and I think they basically just take the next five on the list, and they send those names out to the plaintiff and the defendant, and you can, if you have reasons that you would not want a particular attorney on the arbitration panel, maybe there's a conflict of interest or something else, you can strike. You get a chance to strike two, and send it back, and then from the once the prothonotary gets the responses back, then they appoint these three arbitrators to hear the case.
We probably don't have a really good idea of how many cases are handled on a day-to-day or weekly basis in Indiana County in which an arbitrating panel is involved. Is it a fairly common thing?
It's fairly common. I know. And I don't know the numbers, but we may have 40 or 50 practicing attorneys in the county, and I sit on arbitration panels anywhere from 3 to 10 times a year, just depending on the year. Probably the most I've done is 7 or 8. So that gives you an idea of how often arbitration comes up.
So somebody is involved in a civil case, and they have their attorney who is representing them, and the case is going to come before an arbitrator. So walk me through the process. What happens?
So it proceeds just like a regular civil case would. You can conduct discovery, right? So I can request documents from the opposing party. I can send them interrogatories, written questions that they've got to answer under oath, requests for them to admit certain facts, requests for admission for them to admit certain facts related to the case, and also I can conduct depositions of the other party, oral depositions with a court reporter present where they've got to answer my questions, and on the other party and any relevant witnesses. So that's all the same. And then once your discovery is complete, the arbitration panel is appointed, and you go into this arbitration, and it's the conduct of the hearing is, although it doesn't have the formality of a court setting, right? You're in generally a large conference room, but the procedure is very much the same as a non-jury trial, as a trial before a judge. There are a couple of differences. One is that there are certain, the rules of evidence are relaxed just a little bit. There are certain documents and pieces of evidence that you can have entered on the record without going through the formality of having witnesses testify as to their authenticity and things. For instance, if you have an invoice or a receipt for a bill that you've paid and you're requesting, that's part of your damages, that you're saying, well, I paid this and the defendant should reimburse me for it as part of my damages. You can get that entered in the record as long as you've provided notice, at least 20 days notice to the other side that you're going to present that and move for its admission at the arbitration. So normally I would have had to have if this is a bill from, let's say I had a contractor that came in and fixed some work that was done improperly, and I'm saying, okay, I want to be reimbursed for that. Normally I would have had to have that contractor come in, testify as to the authenticity of that bill, go through the whole thing because it's technically hearsay. But under the relaxed rules, I don't have to do any of that. I just have to give notice to the other side that, hey, when the arbitration comes up, I'm going to be presenting this bill and moving for its admission, and they really, and then that happens. So that's one difference. You've got some relaxed rules of evidence, which is helpful to move the process along. And the other difference is you get a decision much more quickly. The rules require the arbitrators to make a, quote, prompt decision. I don't think it exactly spells out how quickly, but in practice, most of the time the arbitrators make the decision that day, and within 24 or 48 hours what their decision was, as opposed to a trial judge where he's got to write an opinion and detailed opinion and things, and often you don't get a decision for a week or a month.
So in a day and age when most people's ability to understand what's going on in legal situations is based upon which TV show they're watching, which TV judge they're watching, what are the things that you feel people need to know, or are there most common questions when you come into an arbitration proceeding and you are the attorney advising them? Sure.
Well, number one, you need to treat it as though it is as the formal court proceeding that it is, and even though it's in a more of a relaxed setting, an attorney's office or a rented conference room, needs to be treated as a formal court proceeding, and you really need to be prepared for it, and work with your attorney and independently on your own to review what the facts of the case are and any relevant pieces of evidence, so that you're prepared when you come in there to answer the questions that need to be answered, and then also understand, and this is important with arbitration, is that there is a right of appeal from every arbitration. So if you go, before this 3-attorney panel and you make your case, and it just doesn't go the way that you think it should, there is always a right of what they call de novo appeal, meaning that the case is heard brand new, as if the arbitration did not happen before a common pleas judge. So that's something that's important to understand as well.
All right.
Yeah.
These civil proceedings, you got to have somebody that knows what they're doing, and then certainly in this case, you'll need an attorney who has been through the process before and can help you through it. Marshall, thank you so much for being with us. If folks want to know more about it and want to hook up with you for those services, what should they do?
You can always give my office a call at 724-465-5826. Come see us in the RMP, the old RMP headquarters on Church Street, 655 Church Street in Indiana, or go online to www.westernpalawyer.com.
Beautiful. Thanks so much for being with us again today.
Thanks, Todd. Have a great week.
You too.
Todd, have a great week.
You too.